Yes,
May I please, Your Lordship? Lordship, I beg to mention item 25.
25.
Yes, here I'm appearing for respondent number 3.
Yes.
Lordship, I have taken consent from the other side also. Can this matter be taken after 2 weeks?
Okay. On the prayer of Miss MS N. Dungan, learned counsel to the respondent, list this matter after 3 weeks,
2 weeks.
2 weeks. It will 2 weeks, should be 3 weeks, 4 weeks only.
Yes, oblige.
2 weeks, make it 2 weeks.
May I please, Your Worship?
Yes.
I would like to mention one unlisted writ petition. In this analogous matter, in item number 9.
Item number 9.
9. Analogous matter.
What analogous?
Writ petition, Worship.
Hmm.
I'd like to mention one unlisted writ
What is
petition.
the urgency?
It may be taken with the item number 9, Worship. Analogous matter, Worship.
In that case, we'll take up at 2.
Yes. Okay. Worship. Much obliged.
One writ petition or
For today, Worship.
no? How many writ petitions?
Only one.
Only one.
Only one.
Why analogous?
Not sir. Only 100.
Petitioners are different.
Yes, no, same. Yeah, petitioners are different. Not sir. Analogous matter with item number 9. of
We don't
this-
know.
Yes, last.
Anyway, we'll see.
Read the watch.
Lordship, I would like to mention item number 26 and 27, Your Lordship. May I kindly take up this matter after puja vacation, Your Lordship?
26, 27.
Yes, Lordship. In IA, Lordship, we have to produce records, Your Lordship. I have not received the records yet, Your Lordship.
Yeah.
Yes, Your Lordship.
On the prayer of MS Arbasar, Learned State Council. List this matter after 4
The
weeks.
puja, after 2 weeks, Lordship. Lordship, one more item, Your Lordship, item number 10, Your Lordship.
Then
Yes, Your Lordship, may I kindly take up this matter after vacation also, Lordship. I've taken the consent of the petitioner.
item 10.
Yes, Your Lordship.
What is there?
Earlier, Your Lordship, Ithoriram sir was appearing in this case, Your Lordship.
Hmm?
Ithoriram sir was appearing in this case, Your Lordship. Now
cannot
that
take
he's,
up.
no,
No other government lawyers can take up.
I'll take up, like, Lordship, but I'm not ready today, Your Lordship.
On the prayer of MS Arbasar, Learned State Council. List this matter after 3 weeks.
After 3 weeks, Lordship.
Yeah, Lordship. Lordship, I beg to mention item number 22, 23, and 24.
Hmm?
This 22, 23, 24. This
Hmm.
matter become infectious. I may be allowed to withdraw this matter.
Withdraw.
Yes, ma'am.
23, 22, 23, 24. Connected matters, analogous.
Yes, ma'am. Yes.
Your name, please?
M. Lago.
Mr. M. Lego, Learned Counsel, petitioner submits that the matter has become infructuous.
Yes.
Therefore, list of therefore, he prays that. He prays for closure of the matter. Praise the Lord, the matter, the civil division petition is since closed as infructuous.
Yes, ma'am.
Worship, I beg to mention item number 28.
20?
28. Your Worship.
28,
Yes,
yes.
this matter may be adjourned for today, Worship, and
Why?
kindly list it after 3 weeks.
You are for?
I'm for the petitioner, Worship.
On the prayer of Mr.
T. Kyamdo. Kyamdo.
Your name is there.
Yes, Lordship.
28, item
Yes,
28.
yes,
Your
my
name
lord,
is not
28.
there.
28, my lord.
Your name is not there.
Actually, Lordship, I'm appearing on behalf of the leading counsel for this matter, T. Dukam.
On the prayer of Mr. So-and-so, Learned Counsel appearing on behalf of Mr.
T. Dukam, Lordship.
T. Dukam is also not there. Some near.
Ensoki, yes.
And
Actually, he is also associate.
Ensoki, so-and-so. This is the matter after 3 weeks. Yes, next.
Your Lordship, I would like to mention item number 1 and 2, they are connected matter. And then request for a adjournment for today, since like the leading counsel is not feeling well.
Item
1 and 2, sir.
1 and 2. What is there? Nothing is there. We'll dismiss.
No, sir, actually like we have filed for a suspension of an order.
What suspension?
From an order dated 15/7/2023 by JMFC, sir. It's a
What's wrong? What's the problem? What's wrong with that order?
So there is a revision to be made. That's the.
Your only ground is that the respondent has left the court premises
Yes,
just before the pronouncement of the judgment
Yes, sir.
and deposited the check.
Yes, sir.
What's wrong with it?
Sir, kindly give us a brief adjournment so that like we can.
Lordship,
Sorry.
I'm for the respondent number 1, respondent in this
Yes.
item number.
Have you seen?
Yes, the facts are wrong as they have narrated.
No, there's no ground for even for issuing a notice.
Yes.
You are not saying anything other than saying that the learned counsel could not appear before. The respondent has left the
Yes, sir.
premises.
Lordship,
Is
they came late in the court and.
Have you
does ma-
received, has it been paid?
Only 65 lakhs amount has been paid, but the interest imposed by the learned judicial magistrate first class of amount of 5 lakhs has not yet been paid. Accordingly, we have
You
filed,
not challenge.
Ma'am,
we have filed a recovery petition before the learned judicial magistrate first class on 18th of this month.
Sir, in that regards, we have filed an IS, so like kindly give us any brief adjournment.
There must be some ground to interfere.
Yes, sir.
You have not challenged that.
Sir, in that regards, like my senior leading counsel can explain that. So in that respect, kindly give us any short that so that like matter to be fixed
We'll
on
take up
Monday.
it to,
Sir,
you read the file. What
Sir.
is your ground? You just tell. You
Your
just
Lordship,
read the ground.
Senior counsel.
I have read it, you just read it. We'll take up it too. Where is the senior counsel?
She's unwell today, sir. She's unwell. She's not feeling well.
Very serious.
Yes, sir.
Admitted in the hospital.
Not in that condition, but yet today she's not in a position to appear for.
We'll
this matter.
see. You take the file and read. Do you have the brief?
Yes, sir.
Do you have the brief?
Yes, sir.
You read it? We'll take up after some time. Maybe at 2.
Okay, sir.
Take it as a privilege
All right, sir.
as a young lawyer.
Yes, sir.
You read it, we'll see.
May I, Your Lordship?
Yes.
I beg to mention item 30 and 31, Your Lordship. This matter may be listed after vacation, Your Lordship.
Why?
Here actually AAGRS Nabam is
2015 method, what's there?
AAGRS Nabam is appearing. It's not present
Hmm?
today, Your Lordship. AAGRS Nabam is appearing in this matter. He's not
Doesn't
present
matter.
today.
I have read it. You argue the matter. Take the file.
May I, Your Lordship? Your Lordship, I am on behalf of Ketama, Your Lordship. Even he is absent today, Your Lordship.
2015 method, no adjournment. We'll see.
Your Lordship, since yesterday.
Do you have the brief?
No, Your Lordship.
You are for?
I'm for the respondent on behalf of Ketama, Your Lordship.
Who is for the petitioner?
Petition.
I'm for a petitioner in.
What is there? It's a fourth writ petition, I think.
Yes,
Third or
they
fourth
they are
petition.
doing the same thing.
We'll decide.
Only thing, Mr. Tama is not here. It appears Mr. Navam is also not here. That is why.
What's the big deal? You argue the matter, we'll consider their argument.
I have no issues, but I can argue. They should not say that I have argued in their absence. That is the difficult.
They are there.
That I understand.
It's not that
That I
serious,
understand.
serious
But
matter when
it's-
the
it's-
additional AG is required.
It's like taking advantage of their absence. Otherwise, I will not be contesting the item number, I'm sorry, in which Mr. Tama appears. I will not be contesting that. In fact, my lord, on the last occasion, if Mr. Navam had agreed, I was making a proposal. Apparently, justice violated in both the cases. Let both the petitions be allowed. Let the authorities decide.
Decide finally.
Yes, that is what I wanted to.
We'll make
Sure.
some observation taking into the consideration of the earlier observation by the court.
Yes. So item number 31, I will not be contesting.
It is same thing.
And
Same.
there is some other issues. I have been made a party there. I will not, because it appears to be the same thing. So no, actually no adverse order against them. But I don't know if they want to contest my case or not. That is, I am not very sure.
This is the whole difficulty. What happened to learned additional AG?
Your Lordship, he's out of station, Your Lordship.
I have no issues because this case I will not be contesting. They might want to contest my case. That is the
Next week, in that case, next week.
Okay, Your Lordship.
Ready? Next week.
Next week, okay, Your Lordship.
Are you sure? The reason is very simple. Matter is also very simple.
Yes.
And moreover, it's a 2015 matter.
Okay, Your Lordship.
Any interim order in your favor?
I think interim order in both the cases.
Interim order is there.
Interim orders.
You tell us when. In that case, he's ready. Next week also. Petitioner is ready.
इसमें तो सब ये थर्ड तक फोर्थ तक नहीं है सर
Nahi hai.
नहीं फोर्थ तक
It appears Mr.
on-
Tama is not available till 4th.
यस
On the prayer of MS P. Pango, Learned State Council.
Nahi rahega.
No. MSP Pango, Learned State Council submits that Mr. R.H. Nabam, Learned Addition Advocate General, who is appearing in this matter on behalf of the state, has some personal difficulties today, for which he prays for listing the matter, prays for adjournment of the matter for further 3 weeks. We'll make it 3 weeks in that case.
Problem.
Yes, Your Lordship.
No, Your Lordship. I beg to mention item number 11.
Prayer is allowed, this the matter after 3 weeks.
I beg to mention item number 11, Your Lordship.
11.
Yes.
Yes.
On behalf of Arts Owner.
Huh?
On behalf of Arts Owner.
On the prayer of Mr. Arsona, Learned Council for the petition, list this matter after.
Puja
4 weeks.
vacation. Much obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 36. I am appearing on behalf of A.K. Singh. And I have taken consent from the other party also.
36. Okay.
Let
On
the
the-
matter may be listed on 22 or
Let the matter be fixed.
Okay.
After vacation.
On the joint prayer of Learned Council for the parties, list this matter after Puja vacation,
My lord,
fixing the date on
21st.
21st, 10/2020. huh?
deeply obliged.
May it please your lordship. Lordship, in connection with item number 20, a IA is being filed today. It may be called for lordship.
20
Item number 20, lordship, the election petition.
election petition. huh?
An IA is being filed, it may be called for lordship.
What IA?
IA for seeking time, lordship.
So many IAs.
There's 3 IAs were filed yesterday, lordship. We have to file reply against those IAs. That's why we'll take.
I said
Then why is the beauty of election petition, my lord? IAS from both sides.
हम कैसे मुझ को लेता है सुनो आइटम नंबर 11 हम लोग का 16 है ना
Yes, my lord.
हम रेडी हो जाएंगे
I beg to mention item number 17. Item number 17.
17.
Yes, my lord.
Yes.
On behalf of Father. My lord, I may pray that matter may be taken up after Puja vacation.
We'll see. It is listed for orders. We'll see. Wait for your turn. We'll see. It is listed for orders.
Yeah, please.
My lord, I be kindly allowed to mention and pray for adjournment of item number 32 to 34 on behalf of M. Kato. First, he is out of station, and second, my lord, the respondent has died, expired. So the respondent had expired, so would like to implead his wife. So at least 4 weeks time may be granted, my lord.
Or hearing is exhausted.
May I, Your Lordship? Your Lordship, I am on behalf of Ketam in this case, Your Lordship. And then respondent in this case is already he's passed away, Your Lordship. So now
I heard Mr. M at the Learned Council appearing for Mr. M. Kato, Learned Council for the appellant. and Mr. So-and-so
Jayashree.
appearing for Mr. K. Tama, who have jointly submitted that the respondent has expired during the pendency of this appeals, Mr. Therefore, both the parties have prayed for some time to file appropriate application for substitution. Next, prayer is allowed.
My lord, 4
List
weeks.
these matters after
4 weeks.
4 weeks.
Oblige, your lordship.
Finish. Yeah. Yes. Why not three?
Lordship, sorry, Lordship, I think the person who had mentioned item 1 has wrongly mentioned item 2 as well.
Yes, yes.
2 is
I
my
think
item.
Two, yes.
Yes.
All two. Yes.
My lord, there is a title suit filed by the respondent plaintiff. The matter had reached the defendant evidence.
You have not been allowed to adduce evidence.
Yes, I had filed review against that order that has been dismissed on frivolous grounds. The ground,
Why this was dismissed? What is the ground of dismissal?
the ground of dismissal, number 1 is that the 3 dates were fixed for 3 consecutive dates were
Yes.
fixed for examination of the defendant witness. But as per records, I was to be examined only on 23rd of January 2024. By that order on 23rd, it was already mentioned in the order that I am deemed to be dropped as per defense witness number.
2008-2024, impugn order.
Yes. No, that's not the impugn order. The impugn order is 20 August 24.
Yes.
So by that order on 23 of January, I was already dropped. Then on 24, the defendant evidence was closed. So that is why I had filed a review petition against these orders. And it was dismissed by the impugn order dated 20 of August 2023. Now the grounds on which it was dismissed that I have mentioned in page 10, paragraph 17. Number 1 dismissal was that saying that since there were 3 consecutive dates, I did not appear in those dates, but I was called only on 23rd. And by 24th, I was not allowed to be examined. Then another ground was that since the review application was made against 2 orders and not just 1 order. So therefore, the language of section 114 of the CPC allows for only 1 order, which in my humble submission is not tenable in law. Because of the General Clauses Act, section 13 says that when there is something is mentioned in singular, it also means a plural. So obviously in this case, that could not have been dismissed on that ground. So these are the grounds by which the Honorable Trial Court dismissed my case. The order of dismissal is at page 102 onwards.
Will issue notice, otherwise you could have disposed of the matter.
Yes, Lordship, but since the defendant's evidence had been closed, and since if the trial proceeds, otherwise I wanted to ask for an interim order, because if it the next stage is only for arguments, and then it will be over. The next date is fixed in the month of November.
What's been closed?
Lordship?
Defense evidence already closed.
Yes, already closed.
What can we do now?
No, in the next date is for court witness, and then it will be. So this is why I'm making if this order is set aside, then I may be allowed to be, I'm praying also for a direction to.
Problem is that we will have to hear the other party.
Yes, that is why I'm praying for a stay order, Lordship. Otherwise, I would not have.
Had MS Ndangel, learned counsel to the petitioner. By filing this application, the petitioner has assailed the order dated 20/08/2024 passed by the Civil Judge Senior Division 0 in IN number 14 of 2024 in title suit number 08 of 2016, whereby the review petition of the review petition filed by the
Review
petitioner.
petition number 14.
Review petition filed by the petitioner has been rejected. Mr. Issue notice to the respondents. Only one respondent,
Yes.
returnable by 4 weeks. The learned counsel for the petitioners to take steps for service of notice upon the respondent number 4. Also respondents to answer. Arrested. Considering next paragraph, hard on the interim prayer, next paragraph, considering the ground of rejection of the review petition of the petitioner is essential on the ground, essentially to the effect that what is that main ground of rejection?
That is, Lordship may see page 102 onwards. Page 108. Lordship, I have mentioned in page 17 of my petition.
17.
Para 17, page 10. These are in italics.
No, then just wait. Considering that the petitioner has right to adduce evidence in the trial. Come on. The said right has been appears to have been deprived by passing the interim order. Come on. In the interim proceedings, will say
Yes, Lordship. Further proceeding.
the further proceedings of the
Title suit number 8
Title
of
suit
16.
Number 8 of 2016, pending before the Chief Judicial Magistrate, the Civil Judge Senior Division 0 shall remain suspended till the returnable date.
Obliged.
List after 4 weeks. Yes, madam.
If it may please your lordship, my lord,
Yes,
the case of the petitioner is that a dispute arose between the petitioner and his elder brother, your lordship, and pursuant to that dispute regarding a plot of land, your lordship, which was gifted to the petitioner by their late father. And pursuant to this dispute, your lordship, Rani Bana Kabang was held, your lordship, on the complaint made by the
where is the impugned order?
impugned order is at page number 55, your lordship, at 9 series. I'm telling you,
55,
the petitioner is challenging the order of the civil judge, your lordship, senior division.
Civil Judge Senior Division.
Yes, your lordship. Page number 54, annexure 9 series.
So what's wrong?
On
What's
two,
wrong in the,
on two counts, your lordship. The first is that the learned civil judge has come to a conclusion that the order passed by the Bogum Bokang Kawang Your Lordship that was arbitrary on the ground that section 15(4) of Arunachal Pradesh Civil Code Act would apply, Your Lordship, which says that party can go for an appeal only if both the parties consent to the appeal, Your Lordship. However, this particular section, Your Lordship, it has been amended by the Assam Frontier Administration of Regulation Act 2023, Your Lordship, wherein an amendment was made under section 13, Your Lordship. In this particular,
That would be a very strange provision. How can there be an appeal?
yes, Your Lordship.
How can there be a provision of appeal only on the consent?
Yes, Your Lordship. This provision has been amended, Your Lordship, and I'm on this ground, Your Lordship, since an amendment was made on the particular
Should-
provision, Your Lordship.
It should not have been in the statute book.
I beg your
There
pardon.
cannot be any provision for an appeal only on the consent.
Yes, Your Lordship. That is
Is
why
it,
the,
sir? What do you say?
Has to be provided by statute.
Yes,
yes, Your Lordship.
be appeal of consent.
yes.
That is why the petitioner is before Your Lordship, Your Lordship. The
So what is that,
particular
where it
section,
is held?
Annexure 10 series, page number 66, Your Lordship. This is the
66.
Arunachal Pradesh Civil Court Act, Your Lordship.
No, where the civil judge has held that?
At para 27, Your Lordship.
27.
May I, Your Lordship?
Yes.
In the case in hand, the impugn ex parte Kabang decision was passed by the BVK, which is the apex customary court of the Adis, and no doubt the AP Civil Courts Amendment Act 2022 has given statutory recognition to the Inter-Territorial Customary Court, Bango Kabang amongst the Adis, and the apex customary court, Bogum Bokang Kabang of the Adis. But section 15(4) of the AP Civil Court Amendment Act 2022 provides that an appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court or apex customary court by whatever name called, which shall settle the case as per the local traditional customary laws under the provisions of the section 40 of the Assam Frontier Administration of Justice Regulation 1945. And basing on this, Your Lordship, the learned
Yes.
And basing on this provision, Your Lordship, the London Court came to a conclusion that since there was not an agreement, not a consent between both the parties to go for an appeal, the order passed by the Bogum Bokang Kabang was arbitrary and it could not have been done, Your Lordship.
So which provision you are relying now?
I'm relying upon, my lord, may kindly come to page number 68, Your Lordship. This is the 10 series. I'll be relying upon section 13. Amendment,
So take you this, what is this amendment?
amendment to the, at page number 69,
Hmm.
section 13, Your Lordship. Amendment to the Arunachal Pradesh Civil Court Act, clause 1. In the Arunachal Pradesh Civil Court Act, in section 15, in subsection 4 of the words, for the words, if agreed to by the parties, the word shall be the words, if agreed to the parties, by the parties, or if the agreed party desires to appeal, as the case may be, shall be substituted. I'm relying upon this, Your Lordship.
In the Arunachal Pradesh Civil Court Act, in section 15, in subsection 4, the words if agreed to the this, if agreed to by the parties has been substituted by what words?
If agreed, it has been substituted by, if agreed to the parties, by the parties, or if the aggrieved party desires to appeal, which means that either of the parties without the consent of the other party can appeal further, Your Lordship.
It's still, that's why I'm saying, it's still it remains
Yes, Your Lordship.
if agreed to by the parties or
Or if the
if
agreed
the
party,
agreed party desires to appeal.
yes, Your Lordship. If the agreed
If
party,
agreed to by the parties, it still remains.
it still remains, but then there is another addition to it, Your Lordship, that if the agreed party, any of the agreed party can further go for an appeal, Your Lordship. If
It will-
agreed to by the parties, or since there is an or, Your Lordship, and it is an addition, Your Lordship. If the agreed party desires to appeal,
What does it mean?
it means either of the parties, Your Lordship. Either of the agreed parties can go
But
for
it
without the
remains
consent.
the same if agreed to the parties or if the agreed party desires to appeal.
Yes, if this addition was not there, Your Lordship, if agreed, if the agreed party desires to appeal.
What
Your
sort of amendment is this? Where's the original, that thing? Amendment Act 2022, 67.
Page number 60, relevant portion is at 67, Your Lordship.
Hmm.
After the fourth proviso to subsection 3 of section 15, the following subsections shall be inserted.
Whatever police shall settle the case as per this also, provided self before civil council. As the case may be, as per the territorial agreement, provided the courts of the, where it is.
My lord, at clause 4, Your Lordship. An appeal from the village authority,
Hmm.
if agreed to
If-
by the parties, shall lie before the inter-village territorial customary court or apex customary court.
That's how this 2023, I mean, remains the same. Only addition is if agreed by the,
Parties.
but this, if agreed to by the parties, remains the same.
Yes, Your Lordship, it remains the same, but then an option is given that either of the parties who has been aggrieved by the impugned decision can go for and further appeal without the consent of the others, Your Lordship.
This amendment is also equally strange. Either you have to remove it,
Yes, Your Lordship.
you have given the same thing and just you have put something more. But that thing remains, no, if agreed to by the parties, it still remains.
Yes, Your Lordship, it remains, but an option, another option has been
What
provided,
option?
that either of the agreed parties can go for a further appeal.
Anyway, we'll see. Heard Mr. Ditam, learned counsel for the petitioner, by filing this revision petition, the petitioner has put to challenge the order, the judgment and order that is 0708/2024 passed by the
Civil Judge, Senior Division, Pasigar.
learned civil judge within bracket senior division Pasigar. In civil appeal within bracket Kebang number 154 of 2023. By which the decision that is 0908/2024 passed by the Bokung Bokang Kebang has been set aside. And the decision of the village authority of Rani village that is 2904/2024 is upheld. Issue notice to the respondents. And the council to petitioners to take steps for so instructions, huh? Returnable, you just issue notice, respond returnable by 4 weeks, huh? Next para. In the third on the interim prayer, next para. The learned civil judge, senior division, Pasikat, appears to have essentially relied the provision of section 15 within bracket 4 of Arunachal Pradesh Civil Codes within bracket Amendment Act 2022. That the no consent that parties have not consented for filing an appeal, and the decision of the Bogumboka Khaba is an expert decision. Therefore, allowed the appeal and set aside the decision of the village Bogumboka Khaba and upheld the decision of the village authority of Rani village. The Arunachal Pradesh Civil Courts within bracket Amendment Act, Courts Act has been further amended by notification dated 12/04/2023, whereby the words the expression, if agreed to by the parties, has been substituted with the expression if agreed to by the parties or if the agreed party desires to appeal. The expression if the agreed party desires to appeal has been inserted in section 15(4) of the Arunachal Pradesh Civil Courts Act 2021. Having considered that the learned civil judge senior division has not taken into account the amendment of the Arunachal Pradesh Civil Courts Act 2023, in the interim, the imperial order dated (07) 08/2024 passed by the civil judge senior division in civil appeal within bracket Kebang number 154 of 2020 shall remain suspended till the reasonable date. Just after 4 weeks.
Much obliged.
But there is a confusion.
Yes, Your Lordship.
Are you inside the jail now?
My lord?
Are you inside?
No, my lord.
Then, what's the question of regular bail?
My lord.
Yes, what do you say? He was granted interim bail, right? And then that has not been made absolute. Finally, ultimately, bail application was rejected, has been rejected. Now they are filing a regular bail application.
Yes, without arresting, no, elder bail cannot, is not maintainable.
Initially, my lord, since.
Yes, I've
was-
understood.
Yes.
Initially, you have filed a pre-arrest bail.
No, my lord, reported, my lord, so far the facts is concerned, I was arrested and accordingly I was there inside the jail, inside the custody for, my lord,
Okay,
1 month. And after 1 month, my lord, this interim was granted. Now, while in that bail hearing was conducted, my lord, the bail was rejected.
That's why I'm asking, you have not been rearrested?
My lord, so far I have not been rearrested, my because my lord, while
You wait for that,
my lord,
the
today is the,
moment you are arrested. you
no,
come back.
my lord, today is the last date. Thereafter, my lord, if kindly, my lord, go through the bail, where my lord, this is said that the surety was directed to produce me before the IO, my lord.
Yes.
Within a 1 week, and 1 week is, my lord, expiring today, man.
So how can, if you are not in a jail, how can we grant you a bail? Regular bail?
My lord, since my status is, my lord, under arrest, my lord. And this is due to the exceptional case of my problem, my lord, I was granted the.
What is the offense?
It's a murder. 103.
So for
BNS.
my lord, the allegation is offense is 103 and the section 3 of the 5, my lord, common intention,
103.
my lord. In connection with the Pasigat PS case number 94, 103, my lord. In fact, my lord, what had happened is, my lord, I am the,
What is that order? Order of the,
my lord, page 21,
21.
my lord. My lord, got it? Page 21. Learned Council for such and such, PPS also present, House Board and Learned Council to IO on the previous text was fixed on such and such that it is submitted by the council for the accused make the absolute interim bail. This interim bail was granted me on 28/8/2024. As the accused is required to look after the mother who was the child of the Pasigat, and she again required for the checkup. So, my lord, thereafter, when this was finally disposed on 29 September, whereby my lord will find the operating in page number 23.
As the result,
As a result, bail rejected with the direction to appear before the IO for taking him in custody, and security shall produce the accused before the IO within period of 1 week. So, my lord, this regular has been filed by me personally since I am outside at this stage. So, my lord, at least let the CDB call for, and in the meantime, my lord, I may be protected to continue remain, my lord, outside, my lord. So, my lord, my personal case is here that I have lost my father in
call for the case that you will fix it on Monday.
Monday, my lord.
Yes.
Can you obtain?
No.
You get the scan copy,
Obliged. Here,
get a soft,
interim was granted only on the ground
get
that.
a soft copy.
Yes.
Monday we'll fixing it Monday.
My lord.
It's very difficult.
Till then, my lord, I may be allowed to remain.
No, I'm not convinced. Even if your interim bail has been rejected, if you are not arrested till today,
my lord. My lord, today is the last day.
Question of regular bail doesn't arise. So we'll see on Monday.
My
All right. Am I clear?
My lord.
You have not, admittedly, you have not been arrested.
My lord. Not arrested in the sense, my lord, as per
According to
direction,
you-
I am supposed to, my lord, I am supposed to surrender before the IO, my lord.
But then you are not.
Yes,
You have
today
not
is the
been
last day.
once you are granted on bail,
That
you
was,
are released, right?
my lord.
Now that has been cancelled and you have not been rearrested. You have to be formally rearrested.
Rearrested, and today is the last.
Unless it is rearrested, we cannot grant a regular bail. It's not it.
My lord. I clear on that part, my lord.
Or it is not correct.
No, my lord.
Is it correct or not correct?
It's correct, my lord.
Okay. Then I cannot grant you bail now. We'll see it Monday. All right.
My lord.
Not happy?
Having no option, my lord, I have to
You might have
So-
thought about this also. Before moving this bail application, you might have thought about this also,
my lord,
isn't it?
definitely one.
Had it occurred to you? In such situation, what should be, I mean, what course of action should be taken?
Yes, my lord, definitely. So therefore, my lord, this regular bail has been filed.
Yes, I mean, but you are not admittedly been rearrested, and you are not in custody.
My lord.
So
Even,
the question
even
of regular bail doesn't arise.
I was already arrested and the bail was already rejected.
Okay,
So, my lord,
we'll see on Monday.
Tuesday, Your Lordship, 1st of October.
He'll be rearrested today only. On technical ground only, we're just asking you to, I mean, fixing the date on Monday.
Yes, I'll try to
Right.
manage this.
Monday, not try. You have to get this through the soft copy.
Oh,
You
yes.
talk to him, the IO. Get the soft copy. and we'll see.
My lord.
Status also, huh?
Yes.
Case diary along with the updated status.
Status report of that.
Had Mr. C. Modi, Land Council for the applicant. This is an application under section 483, BNSS 2023 for grant of regular bail to the ex-person Sri Batum Kaki in connection with Pasigat PS case number 94 of 2024 under section 103 within bracket 1 bracket close 3 oblique bracket 5 bracket close BNS 2023. First one is BNSS, huh? Second one is BNS. It is submitted by the Land Council, submitted by Mr. C. Modi, Land Council for the applicant, that the petitioner was arrested. When?
27/7/2020.
On 27/7/2024, and was released on bail,
Interim
on interim bail
on 28/8.
on 28/8,
28/8.
2024. Mr. Bhava, however, finally, ultimately, the bail application has been rejected by the London Session Judge with a direction to appear before the IO for taking him custody within a period of 1 week. By the order dated 21/09/2024. Next. Having considered the submissions, I am of the view that since the petitioner has not been taken in custody as on date, the regular bail application, the maintainability of this bail application is to be considered. Mr. Be that as it may, let this matter be listed on 30/09/2024. Mr. The learned Mr. G. Tado, learned additional PP for the state cell. Produced the scanned copy of the case diary along with the updated status. This accordingly. Okay.
I'm sorry to interrupt, Your Lordship. My lord has reflected a judgment and order, Your Lordship. There's a decree as well, Your Lordship. My lord may also.
Decree. Decree, is which date? Same.
Same date, Your Lordship. 07.
Judgment and decree dated so and so, huh? In that case. Item 2, item 3.
3, Your Lordship.
Ah.
Much obliged.
Yes.
Hello, this is bail application.
Ah.
File under
Section. Mr. So learned counsel for the petitioner. This is an application under section 483 of BNSS 2024-23. Praying for grant of bail to the accused person. Namely, what is the name of the accused?
Pungming Bagang.
Srimati Pungming Bagang, alias Mimo Rimo. In connection with Itanagar Women PS case number 24 of 2024 under section 363, 376 within bracket 2, bracket close, bracket J, bracket close 366, capital A, 370, 370A, 120B oblique 34 of IPC. Call for
Read with
section 6/8 of POXO Act 2012 and 3456 3/4/5/6 of immoral trafficking within bracket prevention bracket clause act. Call for the
Notice, Your Worship. Notice to the respondent to
okay.
POXO here in.
So we'll call for the case diary.
You're
First-
already
firstly-
charge sheeted
Okay. Call for the scan.
for 98 days.
Hmm?
98 days she is in judicial custody.
The offense is so serious.
Yes.
So actually, my lord, that accused person is not involved in
That's
this
the
case.
matter on 04. Will it be all right?
Yes.
04.
She is innocent in this
10
case. my lord.
2024.
She is innocent in this case, my lord.
Every accused
But,
says so.
but she is in the judicial custody for the 98
That
days.
is the common submissions and the common grounds
Yes.
for the accused.
So considering of that
Thank you, sir. We'll see.
much of this.
Offense, sir.
Letter 307, 304, 506 minute IPC.
Will issue just notice, that's all.
This is joint application, my lord.
Doesn't matter. 304.
My lord. My lord,
Not Mr. L. Perme, land counsel for the petitioner. Next para. By filing this application under section 528 of BNS 2023, the petitioners have jointly, by filing this application jointly, under section so and so, the petition 2020, BNSS 2020. The petitioners have prayed for enforcement of the sessions case number 05 of 2024, arising out of Nizuli PS case number 91 of 2023, under section 307, 304, 506 IPC, pending before the session judge UPIA. Call for the scanned copy of the trial court records. Next para. Mr. G. Tado, learned additional He appears for the state. Okay, Tizini, sorry. Tizini. Pending production of the trial court record. the further proceedings of sessions case number 05
My lord.
of 05 of 2024
2024, my lord.
pending before the session judge UPI shall remain suspended.
High level.
Yes, this after 3 weeks, make it 3 weeks.
My lord, this is.
302.
302, of course, it's there, but the circumstances, my lord.
This okay, learned counsel,
And one more interesting thing, my lord, as per the, my lord, the petitioner number 1 is not even aware now that the trial is going on. Only when on 25th, my lord, the depositions were sought for, then only the petitioner number 1 came to know the trial is proceeding in his absence also.
There's a provision, you can avail that provision during the trial. When,
That is there, my lord.
when you are intoxicated. Yes,
Yes, your lordship.
Yes.
Election.
Because here, in fact, the petitioner number 1 is the person who is suffering, my lord. And his family as well, because it was caused
See,
in such a manner, my lord.
they say there is, are you believing, do you believe in karma? Karma,
Of course, yes. my lord.
it's karma. It's very difficult.
Of course, it's difficult, but there is no absolute bar as such also, my lord, that my lord will see the circumstances all of my lord will call the records and see, my lord.
Till
but,
returnable debt.
my
Till
lord,
returnable debt only.
my lord.
302.
Yes, my lord. Of course.
Mr. Disoki, learned counsel for the. This is a joint petition, no,
Joint petition.
petitioners. Next para. By filing this application under section 528 of BNSS 2023. The petitioners have. You just said petition jointly, huh? The petitioners have prayed for quashment of the Basser Sessions case number 01 of 2023 under section 302 APC. Pending before the additional session judge Basser. MS TG learned additional PP appears for the state. Call for the scanned copy of the case diary, scanned copy of the trial court report. Next para. Considering that the present application, that the present petition has been filed jointly, and the accused is the wife of, accused is the brother.
Yes.
Who is
Bro-
this petitioner number 2?
Petitioner number 2 is the wife of the
Disease.
Yes,
deceased.
Brother of the accused. The brother of the deceased. Real brother.
Real brother.
Real brother of the deceased, who is stated to be looking after the children or a child,
Children, 2 children,
Children.
the deceased.
public children, and the wife of looking after the
Family of the
family
deceased,
of
not
the deceased. Come on. Till returnable debt. The further proceedings of the Basser Sessions case number 1 of 2023 under section 203 pending before the additional session, Judge Bassett shall remain suspended.
Deeply observed. Wait, please, Lordship.
Yes,
My lord, I have.
it's a forest land.
That is my second point.
Yes.
And I have raised the legality of that process itself. No notices were issued.
What is the requirement of notice?
My lord, in Assam forest regulation,
Yes,
Lordship may come to page 48.
48. Yes.
From page 50, my lord,
Hmm.
section 4. The state government may constitute any land at the disposal of the government, a reserve forest in manner hereinafter provided. Lord, I pause here, my lord.
Hmm.
The language itself is land at the disposal of the government. Before a land is declared as a forest reserve, the requirement is the land must be
At the disposal of the
of the
government.
government. And your lordship is aware that a land at the disposal of the government has to be acquired or donated. Now, my lord, thereafter, my lord, in processes from section 5, 6, 7, notices has to be issued. And my lord, it has to be acquired as per the provisions of Land Acquisition Act. Now it has been repealed by LARA. Compensation has to be paid. And my lord, section 11 at page 52. Then
In case of a claim to a right in or over any land other than the following rights, a right of way, right to water course,
my lord, the requirement to issue notices is not only a mere formality. It has to be in fact issued. And there must be.
So difficulty out is there, the implementation, this law of Assam Forest Regulation. It talks about the order on the claims to right of way, water course or posture
My lord, that
of
is,
the forest produce.
the location is.
It doesn't say anything about the right of the right and title of the land
Yes.
itself.
So, my lord, at this stage, my lord, let the notice issued, and on the second point, let the government and forest department clarify. But first thing is, my lord, the first issue is, my lord, the deputy commissioner, you also may have to come to page 21, annexure 1,
51.
21. This is my first issue. My lord, this area, Siku Bana query,
51, page 51.
21, my lord, 21.
21.
But without any proceeding, without giving any notice to me, may I read, my lord? Whereas Sikubanda query under Mebo subdivision, East Siang district was notified as private query in the year 2017 by notification number such and such by the district administration in the interest of public for extraction of the querying of minor minerals. Whereas on inquiry, the by divisional forest officer Pasigat report number such and such, Sikubanda has been found under Mebo Range Forest Reserve area. Now, therefore, I, such and such, Deputy Commissioner East Siang District, considering the report of the divisional forest officer, suspend the notification of Sikubanda query dated 19/12/2017 with immediate effect from the issue of this order. Further, divisional forest officer are directed to comply with this order and check illegal quarrying oblique mining of minor minerals from the Siku area, my lord. My respectful submission is this Siku area banner query was notified by following due process of law. My lord, your lordship may kindly come to paragraph annexure 4 onwards. My lord, I have applied committee will constitute a geotechnical committee where the DFO Pasigat was a member. They have clarified.
Next, this
Now, in any case,
notification of is of 1985.
85%.
this reservation is 1985. That's why, my lord, to the extent it includes my area, I am challenging. But before that, my lord, this
Okay, we'll issue notice. Not Mr. T. Pratik, learned counsel Pratik. Petitioner, only one petitioner. Only one
only one.
petitioner. By filing this application, filing this petition, the petitioner has put to challenge the order dated
26 July.
Huh?
26 July 2024, madam.
26/07/2024.
Well, before issuance
Issued
of
by-
this order,
filed by
we never knew that this area falls under forest.
Deputy Commissioner Pasigat, whereby the notification dated 19/12/2017, notifying the Tikubane quarry as private quarry has been suspended on the basis of the report of the divisional forest officer within bracket territory.
No, without drawing up any proceeding, no so cause notice. madam.
Division forest officer of territory of what? Where?
Of Pasigat.
Pasigat, huh? Pasigat. Mr. The petitioner has also challenged the
Madam, type copy space
notification of
33.
notification declaring the Mebo Reserve Forest dated 02/02/1985.
Madam, to the
Issued by
extent,
the-
yeah, madam, to the extent it includes my area.
Final the notification, huh, declaring the Mebo Forest area. Mebo Reserve Forest
Yes, that's it.
of measuring approximately 39 acres of Aing village, including the
Madam, 39 acre is my
okay.
of the Ayang village, including
Aing village
39
in
acres of
respect of the
the petition.
petitioner dated 02/02/1985. Issue notice to the respondents returning by 4 weeks. MSG at the London additional senior government enters appearance on appearance
For 1, 3 and 4 lots.
respondent 1, 3 and 4.
Yes, lots.
No formal notice need be served, however, extra copies to ensure, huh? Have you served the copy to respondent number 2?
Yes, madam. 2.
The learned counsel for the petitioner to take a stage for service of notice upon respondent number 2. You may furnish
My lord.
to the standing counsel.
Lord, in the meantime, my lord, page
Next
21.
paragraph. considering that the impugned order dated 26/07/2024 passed by the Deputy Commissioner Pasigat appears to have been passed without following the, without hearing the, without providing an opportunity of hearing
Lordship, may I?
or
Lordship-
notice,
Yes.
till returnable that the impugned order dated 26/07/2024 shall remain suspended.
Obliged, Lordship.
It appears that
Since this falls under the reserve forest, Lordship, and then at this stage, we don't know, Lordship.
we'll see, the notification, we're not staying the notification of reserve forest.
Yes.
Not of that can.
You have issued a notification notifying this CK Bane query as private query.
Yes,
If you want to cancel, you should hear him. We'll provide. The pendency of the present proceedings, it is made clear that pendency of the present proceeding shall not be a bar to the Deputy Commissioner to issue notice to the petitioner. No, shall not be a bar to hear the
Parties.
parties, hear the petitioner after by providing opportunity of hearing. You immediately issue a notice tomorrow and next day you hear them and pass the same.
Would have been better, Lordship, because they will,
Obliged, Lordship.
this is sensitive query, Lordship, they will.
No, you have declared, you have
Every right
issued a
is-
notification
This.
declaring it's a private query. And on just report on the report of the this
DFO.
DFO, you have just suspended it. It doesn't show anything.
Lordship.
Can you just read it, impugned order.
I have, Lordship, I have gone through.
It doesn't indicate that whether any
Yes.
notice has
Any
been,
notice has been given,
just because of that only.
Lordship.
Obliged.
May I please, Lordship?
Yes.
Lordship, this is a tender matter.
Yes.
Yes, Lordship.
Yes.
Lordship, the respondent authority has, that is Executive Engineer Sangram PWD Division, has issued e-tender being tender NIT number so and so.
Where it
The-
is, where is the tender? Where is the NIT?
Yes, Lordship, that is in
What is the date of tender?
annexure,
When it was issued?
annexure, page number 22, Lords.
There is no date.
Page, yes, date is not there.
Then how do you know?
Lordship, they have not mentioned the date.
How did you participate?
Thereafter, Lordship, I have participated and in the tender and Lordship, page number 30. Page number 30, minutes of bid opening. Lordship, here my firm is United Pisa Construction. Your Honor, Lordship, during the time of,
It's okay. Before that, we'll have to understand that we'll have to know what is the date of tender, NIT.
it was on 21/3/2024. I have made in my abutment, para 3. In the website. 21/3/2024. As they have uploaded in their website or
21/3/2024.
3/2024, Lordship.
Then
Thereafter, Lordship, I being the eligible bidder,
you are declared to be L1.
Lordship.
Then
Thereafter, what happened is that Lordship may kindly come to annexure 40, page number 40, annexure app.
yes.
Lordship, may I read this? Lordship, here some complaint has been received from 3 individuals. They have stated that the tender has to be cancelled as because the present tender has been plotted during the ensuing general election come Lok Sabha election. Lordship, upon receipt of the complaint, the DEO, that is District Electoral Officer, has written a letter to the Executive Engineer, Sangram PWD Division, to hold the tender and to keep the tender in abeyance.
Yes.
However, the Executive Engineer PWD Division Sangram has cancelled the tender wherein I was declared as L1, Lordship.
Where is the cancellation?
Yes. Page number 37. This is a common cancellation order, Lordship. Page number 37, office order, dated 22/5/2024. Notice inviting tender number so and so. There are around 7 packages in this tender of work under PWD Koloriang Kurungkume Division, which was plotted during operation of MCC is hereby cancelled, Lordship. This order is being issued by following MCC rule ECI letter dated so and so 5th March 2009 and also letter from District Election Officer Kurungkume District Koloriang by letter dated so and so dated 9 March 2024 and complaint from vested public youth of the Panchayat and the Panchayat leaders.
Where it
Lordship,
is?
Lordship,
Page 38.
this is
Page 38.
Lordship.
Hmm.
This is the cancellation order passed by the Executive Engineer
She
Sangram.
was plotted during operation is hereby cancelled. Yes.
They have in the cancellation order, they have stated that they have followed the recommendation of DEO. However, the DEO has never said to cancel the tender. The DEO has said that the tender has to be kept in abeyance.
Yes.
Being agreed with this tender, other bidder other than me, Lordship, they have also filed similar writ petition.
You are concerned in this petition, you are concerned about which NIT?
Lordship, that is NIT dated,
E-tender number?
yes, e-tender number SGM DNIT oblique KLG 203/204/11.
204/203. Hmm?
That is with respect to the work of Kiarop Circuit House at Sarli under Kurungkume district. Package number is different and the name of work is different, Lordship.
That's why I'm asking, which one? There are so many tenders have been cancelled.
That
Which
is
one you are in page 38?
okay.
Which package or which work?
I'm coming, Lordship. That is Lordship SGM
11.
NIT KLG. That is in third line of my typed out copy.
24/11.
Lordship,
Okay.
Lordship.
For construction of
This is for construction of
circuit house at
at Sarli
Sarli.
under
Under
Sarli
Sarli
Circle, Kurungkume district, Lordship.
Hmm.
Lordship, other petitioners also prior to me, they have also approached before this honorable court and this honorable court has granted stay order. That is page number 83. Annexure J. Kohli,
Page
page 85, relevant portion.
85.
Yes. Page 87, serial number 9.
The order of cancellation of NIT dated so and so,
Respond to this.
dated 25/5/2024, issued by the Executive Engineer Sangram Division, shall be subject to the outcome of this writ petition. Lordship, this is the same impugn order.
Respond.
Lordship, next page, page number 93. Again, Lordship, being agreed with the same impugn order, the another petitioner, that is LT Enterprise, he has also approached before this honorable court for a stay of this impugn order. And accordingly, on 3/7/2024, this honorable court has granted stay order of the same impugn order, that is common impugn order dated 22/5/2024, issued by the Executive Engineer, respondent number 3. Lordship, thereafter, again in page number 96, another writ petition has been filed. That is by AP Enterprise. He is also agreed with the same common order. In his case also, this honorable court has stayed. So therefore, right now, the impugn order has just been cancelled. Nothing has been done with respect to the tender. Lordship, considering the law of parity, this may be
What?
parity, because
Law parity.
Lordship,
This interim order is a law.
Lordship, but Lordship, same reason, same order, Lordship, same impugn order. So ground is also same. Lordship, my prayer may be considered, Lordship.
Yes, madam.
Your Lordship, Model Code of Conduct, Lordship, in page 48, Lordship. It was, Lordship, declared on 16th of March. Order is in 16th of March. And then, Lordship, this NIT dated
Was
is
it in 21/3?
21/3.
Yes.
Lordship, it is covered, Lordship, in the sense.
So as
This
where
executives,
where it says that there cannot be any tender process in the MCC.
Lordship, but then they have got a letter from the MCC.
So as the provision
MCC.
in the MCC that you cannot have a tender, the tender NIT cannot be issued during the currency of the MCC.
That part, Lordship,
Or
I can't say, but otherwise, Lordship, the petitioner is L2, not L1.
I'm L1. I'm
Yes.
L1, Lordship.
As per page 33, you are
Hmm.
L1.
It
L2,
is
United Pizza.
page number 30. Kindly peruse page number 30.
30?
30.
Minutes of bid opening summary. Finance. Consequent upon qualification of three numbers of bidders in the pre-qualification and tender bids process of the project that is care of Circuit House at Sarli under Sarli Circle, Kurunkume district. Called through Arunachal so and so, tender ID number so and so, tender reference number so and so. The financial bid of the qualified firms that is so and so were evaluated automatically by the system through the e-procurement site Arunachal Pradesh so and so. The bids received by closing date that is time 1,200 hours.
L1.
L1.
Yes.
Lordship.
United Pisa Construction.
Lordship. I am L1.
Heard Mr. P. Taba, Learners Counsel for the petitioner. Petitioners,
Lordship.
how many?
Lordship, I am the only petitioner.
Only one petition.
Lordship.
Check up your
Lordship.
page 3.
Yes, Lordship.
Page three.
United Pisa is my firm.
Page 3.
My firm, Lordship.
How many petitioners are there?
Two petitioner.
Then
On behalf of
why
my
you
firm,
did one petition?
Lordship. I am the sole proprietor, in fact, Lordship.
How many petitioners?
There are
One petitioner.
two petitioners.
Then
Yes, Lordship. But I am the sole proprietor, Lordship.
I'm not asking whether you are a multi-proprietor or sole proprietor.
Lordship.
I'm asking how many petitioners?
Two petitioner, Lordship.
Then Learners Counsel for the petitioners. Next para. Challenge made is in this writ petition is to the office order dated, which there is no date also.
Lordship.
22/05/2024
Lordship.
issued by the Executive Engineer, Sangram Division, PWD. Whereby the tender dated 21, NIT dated 21/03/2024 issued for construction of Circuit House at Sarli, under Sarli Circle, Kurunkume district, has been cancelled. Please stop. It is submitted, it is the contention of the petitioner that that pursuant to the NIT dated 21/03/2024 the petitioner has participated by submitting his bids for construction of Circuit House at Sarli, Kurunkume district. By what is that bid evolution?
Lordship, page 30.
By minutes of bid opening. No, minutes of bid opening. Minutes of the bid opening summary within bracket finance dated 08/04/2024. The petitioner, number one, is found to be qualified as L1 bidder. Mr. while the petitioner was anticipating for issuance of anticipation but award of the work being L1, comma, the executive engineer Sangram Division, comma, PWD has issued the impugn order whereby the NIT issued during the currency of MCC, this is Model Code of Conduct, has been cancelled, including the NIT dated 21/3/2024 for construction of so-and-so, circuit house so-and-so at Charlie, whereby the petitioner has been declared as L1 bidder. The London Council, Mr. T. Taba, submits that the district election officer, Colorian, has directed the concerned authorities, but particularly the executive in the Sangram PW division at Sangram by letter dated 09/05/2024, directing only to keep the NIT in abeyance till lifting of model code of conduct in terms of the model code of conduct guidelines issued by the Election Commission of India. Therefore, he submits that the cancellation on the ground of operation of model code of conduct, the cancellation of the entire tender process on the ground of operation of model code of conduct is arbitrary and not sustainable. Issue notice to that we have said, maybe should not. Issue notice to the respondents. They are appearing for all.
No, 1 to 7, Lordship.
Who is 8?
8 is a private respondent.
Lots. Who is private respondent? Why private respondent?
Lordship is L2.
Huh?
L2.
Why L2?
No, Lordship, there is no private respondent, Lordship.
There's no,
There's no private respondent.
there's no private respondent.
Yes, Lordship.
Madam,
There's no private respondent, yes.
it's up to 7 only. Issue notice to the respondents. Next, since
Oh.
MS,
Lordship, they have given me the
No.
other copy, so that's why.
not since, MS G at the London Additional Senior Government Advocate enters appearance and accepted notice on behalf of all the respondents. Therefore, no formal notice need to be served. However, extra copies be furnished to the London Council for the parties. This LT Enterprise, this is in respect of which the
Package.
which package and which same order.
Yes, Lordship, same impugn order, but different package. Different package.
Obviously. But same petitioner.
No, different petitioner.
Hmm?
Different petitioner.
Where it is? Page
LT. Page 87.
Page 87.
Yes, Lordship, page 87 and Lordship 93, 94. Lordship, this matter was filed before the vacation benches at Guwahati. Later on,
All right, we are not interested on that.
Lordship,
What order has been passed? Subject to outcome.
Lordship.
Next para. Considering that the Model Code of Conduct guidelines issued by the Election Commission of India appears doesn't provide for complete cancellation, does not bar the issuance of NIT during the currency of the MCC, in the interim, the order of cancellation, the impugn order dated 22/05/2022 issued by the Executive Engineer, Sangram Division, Sangram PWD Division. Shall be subject to the outcome of this present proceedings. List of. It is also provided that no fresh NIT be issued without the leave of this court. This after 4 weeks.
Deeply obliged. Lordship.
You just said, PMPC doesn't bar, huh?
Lordship, there is also analogous matter, Lordship. Only the petitioner is different and package number is different.
Petitioner different and the
Package number is different.
package number is what?
Package number is, that is
No, this is NIT, this is for construction of
residential building number type 1, type 2 and type 3. At
where it is.
staff of page number,
Construction of residential building, two numbers of type 1 and
type 1,
numbers of
type 2 and
type
type
three.
3.
For stops of page 23, huh? Stops of district administration at Surly CO headquarters, Kurunkume district. Same,
Yes, Lordship, same.
impute order is same.
Yes, Lordship, same.
That's all.
Only here private respondent is there.
Here, private respondent.
This
Then in that case, you.
This
The
petition.
package test for service of notice of arrest. You are L1 here.
Yes, Lordship.
Here also you are
Yes,
L1.
Lordship. I'm
Unless this one.
Yes, Lordship, I'm L1.
Why L2?
Page number,
Why
page,
L2? Why L2 has been implemented?
Lordship. Lordship,
Why he is to be
Lordship, the
Implement as per-
authority might, Lordship, issue letter of intent to L2
why?
by cancelling this, cancelling the order.
Once it is cancelled, the NIT is cancelled. How can you anticipate that this will be issued to L2?
Lordship, I have a opinion that the respondent authority,
In that case, issue notice. We had that. The steps within so. Huh? 3
Lordship,
days you take a step. You
Lordship,
had that.
deeply obliged.
Yes, sir.
Yes.
Hmm.
Lordship, through this petition, I am trying for quashing the criminal complaint case which is pending against me before the CGM Teju. So the facts in this case, Your Lordship, is that I am a resident of the village called Digaru in Teju. And this place is a populated region, it is not a forest land. In this area, I have been living since many generations, Your Lordship, prior to 1976. Now, in order to show my so that I have been living in that place since 1976, I have annexed one trading license, Your Lordship, which was issued to me in the year 1976. That is one. And also, I have annexed the birth certificates of many persons, which will show that it is a village and not a forest area, which are in the which ranges from page number 60 onwards. All the persons are living in that area. Second point. Third point, Your Lordship, this is to show that this is my area. There was one meeting held on July 15 to July 9, 2015 between the Gram Sabha Panchayat members. Here also it was agreed by all the Panchayat members that I am the owner of that land, Your Lordship. May I read out that 11? Okay. This also shows that I have been in the
You are the owner of the land.
Yes,
By the Gram Panchayat.
yes, it was decided and agreed.
Yes.
Now, what I am condensing, Your Lordship, is that since I have been in this area for many years, and since this is under my possession, and I am the ownership of this land from generation to generation, now it is my land. And suddenly, I was issued a notice from the Forest Department saying that it comes under the Digaru Forest Reserve. Now, when this notice was issued, no notice was issued to me, directly eviction notice. Without notice, they directly issued to me eviction notice. When eviction notice was issued, then I filed one representation saying that I have been living in that area for many years and I am the real owner of the area.
Yes.
Now, what the Forest Department did is that instead of addressing my issue, they should have first addressed my issue. Instead of addressing my issue, they directly filed complaint before the CGM Teju, and which is pending before the court, and for which I am here before. Now, my first contention is that since it is my area, they cannot suddenly come and say this is forest area, so you have to move out. This is my first point.
Is it a forest, reserve forest?
No,
Is it declared reserve forest?
they say it is, but I'm saying it is not.
Is there any notification?
They have.
Unless you challenge that, sorry.
No, I'll come to that point, Your Lordship.
What come? Nothing.
Thereafter, Your Lordship, I'm also protected under the
Travel, 2006.
yes. That also
That is a different aspect.
Yes, Lordship.
That is different aspect.
No, Your Lordship.
You may challenge all these things in a availing different appropriate forum, not by, we cannot quash. It's a criminal petition, we are quashing for the complaint.
Yes, but the procedure in which it has been initiated, Your Lordship.
What?
There is the illegality in the procedure itself.
What is the procedure to be adopted?
The first thing is that when they file, when I file representation before them, they should have forwarded the matter to the settlement officer, as given under the Section 6 of the Assam Forest Regulation Act. Now, in the forest.
That is at the time of declaration, the proceedings of the declaration, not after the declaration.
That is so. But
after declaration, that's what I'm saying. You can avail, no one is stopping to challenge that.
But
you are not debarred from challenging all these proceedings. But wrongly or rightly, this has been notified as a reserve forest. I feel for you, I understand.
Now,
but then law doesn't support you. It has been declared as a notified.
Now, if coming to this point about the
so whatever you do, activities you do, it's against the offense against the Forest Act.
If they are speaking about the forest,
therefore that will be they have rightly filed a complaint. If you are agreed that this is your land, the now proper proceedings has been procedure has been followed while declaring the area as a reserve forest, you may able to.
Your Lordship, even if my petition is dismissed, kindly allow me to give a detailed submission.
What submission?
Because now coming to that notification of the forest area,
Then you show us that the forest officer cannot file any complaint before the court.
but Your Lordship, if we go to look at the notification, Your Lordship, the forest notification area, the Digaru Forest Reservation Area, Your Lordship, which they have filed in the affidavit, there, the boundary, Your Lordship, the boundary they have given is
We are
20.
not here to see all this thing. Whether you show us in the criminal for quashing petition, you just show that the officials who made a complaint, or the complainant doesn't have the authority, or there cannot be any complaint against you under the law. You show us that.
This is what I'm saying, you know, before filing.
See,
Yes,
this has been wrongly or rightly declared as a reserve forest. You are staying on the land.
But, yes, Your Lordship.
Individually, I mean, as a common citizen, as a citizen, I feel for you. I understand. But wrongly or rightly, state has declared it as a reserve forest.
Yes, exactly.
And activities you are carrying on, just because your driving license has been given, doesn't give you a right.
Your Lordship, what I'm
So it
submitting-
falls under the offense of the Forest Act.
The offense, the area under which they have filed complaint.
See, these arguments you are trying to project,
Yes, yes.
why I'm refusing to hear you. These are the submissions and the grounds you may take avail the appropriate provisions. I mean, remedy, not in quashing petition.
Just one point, Your Lordship.
Dismissed.
Your Lordship, just one point. Thereafter, Your Lordship will dismiss my petition.
Huh?
Just one more point.
What point?
The complaint for which they have filed complaint against me, the area, the location they have given is different from the one that is notified in this gazetted notification.
See, complaint is against you. You will be given a chance by the court. You clarify before the appropriate court.
But without following the procedure, Your Lordship. So many procedural lapses.
What procedure?
The Civil Drafts Act, which has not been followed, and they have not reported a matter to
Section 6.
Yes, yes.
That is during proceedings.
Yes.
For declaration of the reserve forest.
And then
Not after the declaration. Not after the declaration or notification.
No, not only that. When there's a claim from other party, Your Lordship.
That is during the proceedings
Not
for
so.
declaration.
That is one point, Your Lordship. Second point is that when there is any claim from other
Let
party.
us see.
Yes,
Assam Forest Regulation.
yes, Your Lordship. I don't have this, but I have the printed copy, Your Lordship.
Yes.
This maybe.
Assam Forest Regulation. Six. 1891. Is it 1891?
Yes, Your
Yes.
Now, section 6, Your Lordship. When the notification has been published under section 6, the forest settlement officer.
You read from section 4.
Power to constitute reserve forest. The state government may constitute any land at the disposal of the government a reserve forest in the manner hereinafter provided. Notification by state government of proposal to constitute a reserve forest. Whenever it is proposed to constitute any land a reserve forest, the state government shall publish a notification in the official gazette specifying as nearly as possible the situation and the limits of such land, declaring that it is proposed to constitute such a land reserve forest.
See, up to section 16, you have the right. This is the proceedings before declaration.
Yes.
Then notification will be issued under section 17. Now, notification was issued in the year, madam?
April 1998.
88, yes. You have missed the bus.
Lordship, notice also was issued to him, Lordship, my page 35,
When?
Page 35 of the
22,
when-
21/6/22.
2022.
Yes, Lordship.
No, where the notice we are talking about is section 6. He's talking about section 6.
Lordship,
yellow.
inside the Digaru Reserve Forest, when he started constructing 3 stories building and fish pond, then only Lordship, they had taken note of the
Your Lordship,
enforcement.
if we look at the complaint, Your Lordship, the offense report, if we look at the offense report filed by them, the area which they have filed is the latitude, the degree of the latitude and longitude.
You have a remedy.
That is totally different from the one notified in the notification.
It's before the court, appropriate court. You will be given an ample opportunity to.
But Your Lordship, what about the procedural lapses as regards to the Scheduled Tribes Right Act? Because it says no person shall be evicted from no traditional dwellers shall be evicted. That Your Lordship, may I please take Your Lordship to this?
You just show us, so this court, so to us, so to that while filing the complaint,
Yes.
any violation or any of the procedure safeguards, or according to you, no offense or any activities, what?
Yes, the same act, Your Lordship, the same act for the Scheduled Tribes Forest Dweller Act. The same act safeguards me that my right cannot be affected in any manner. Because by filing complaint against me, they are totally violating my right to live in my traditional area, Your Lordship. This section 4(2).
Sir, this has been declared as reserve forest.
That is what I'm trying to say, Lordship. Before declaring as a reserve forest, they have to take pre-consent.
And 1988. And what is this act?
This is of 2006.
Then,
But it says those people who have been living prior to 2003, Your Lordship. So since I have
that you will be given enough. That's why I'm saying you have a appropriate remedy. You avail all those remedy.
then Your Lordship may pass any appropriate order as deemed.
What appropriate?
As Your Lordship deems fit.
Obviously,
So
writ petition dismissed. Criminal petition dismissed. I pass the order. Yes. Anything else?
No, Lordship. Applies.
We are joint petitions by complainant and accuser.
Your Lordship, on the last occasion, the TCR was called for. However, the registry has not received the TCR, Your Lordship.
Heard Mr. K. Tariq Land Council put the petitioners MS TG Land additional PP submitted. She has not received the. You are supposed to receive.
The registry.
No.
In post this, it is
No,
LCR.
can copy of case record. It's there.
Post this also shows my lord, LCR is there.
JMF
Oh, it's-
Colorial, it's there.
There, I had actually checked the brief at that point. It was not there.
Yes. What is the offense?
Offense is 435, my lord. Mischief by fire or explosive substance amounted more than 100 rupees. And here, the informant's bike was burned down during the elections. My lord, FIR, my lord, FIR at phase 14, type copy is at phase 15, man. Type copy is at phase 15, man.
Yes.
Mary.
And settlement copy is at phase 20th. Annex 3 settlement. And para 2 will be relevant, my lord. That the past party, para 2, my lord, that the past party agrees that the damage caused was not done by the second party, but second party has compensated the past party by replacing a brand new same motorcycle. And they charge it also. Charge it also, but says, my lord, it's presumes the motorcycle has been burned by the accused person.
Where it is?
It is page 20, my lord. My lord will find at page 20 at the third line, my lord. It has been page 20, my lord.
This way.
It has been start from third line, my lord. It has been presumed that Sri Yamdotado had burned down the motorcycle. After burning down the motorcycle, the accused person had fled away from the place.
Who said?
This Sri Yamdotadu is the accused, my lord. Petitioner number 1. Petitioner number 1, my lord.
Page, which page you are?
I'm reading page 20, my lord. Charge sheet. At the third line, start from it has been, my lord. It has
Third
been
line.
that Sri Yamdotadu.
It has been presumed that Sri Yamdotadu had burned down the motorcycle.
And after burning down motorcycle, and it played a attempt were made to arrest the accused person and several suspected places in the ground.
Sorry.
Petitioner number
Your
1.
immediate cousin brother.
Yes. Section involved is bailable but non-compellable.
Yeah, Lordship, yeah, I don't have any objection with regard to quashing.
Heard Mr. K. Tariq, learned counsel for the petitioners. And also heard MSTs in learned additional PP for the state. Next para. This is an application under so and so, huh? Four 82, CRPC so and so. This is an application jointly filed by the petitioners under section 482 of CRPC. Praying for quashment of the what is this case? RNGR.
This is a corresponding GR case, my lord. They have name like this, my lord.
GR case number 255 of 2019. Arising out of Yapin PS case number 02 of 2019 under section 435 IPC pending before the judicial magistrate first class following on the basis of the settlement between the petitioners. Next, madam. The case set up by the prosecution is that on 12/04/2019 at 14:30 hours, a written complaint was received from the petitioner number 1. No, petitioner number 2.
Number 2 is the
Complainant.
Complainant, yes.
Petitioner number 2. stating that a written complaint was lodged on 11/04/2019, alleging that at about 19:30 hours, his bike within bracket Bajaj Pulsar 150cc, public motorcycle bearing registration number Nil chassis number, page 19, chassis number MD2A11CY9 JRF 46010, and engine number DHYRS F74156 was burned down by, has been burned down by the petition number 1. In his absence, as he was on election duty. Next paragraph. A case was registered, on receipt of the FIR. No, a written complaint. A case was registered, being Japan PS case number 02 of 2019, under section 435 IPC. Next paragraph. On the completion of the investigation, the police has filed the charge sheet against the petition number 1. Yes. Under section 435 IPC, which is pending trial before the London Judicial Magistrate First Class. Following Mr. Kefari, London Council for the Petitioners, submits that the section 35 is what? 435 is
Bailable,
bailable.
non-compulsory.
However, the same is non-compellable. Listen. He submits that as per the charge sheet, the IO has clearly stated that it has been presumed that the petition number 1 had burned down the motorcycle, and after burning down the motorcycle, burned down the motorcycle, thereafter fled away from the scene. Mr. Therefore, the charge sheet has been filed on mere presumption without reviewing any materials against the petition number 1. Mr. The product submits that during the pendency of the trial, the petitioner number, both the petitioners have entered into an agreement, being their cousin brothers, on 17/04/2024, and have decided to maintain familial cordial relationship in future. Mr. That effort being the cousin brother and the petition number 1 has compensated the petition number 2 by replacing a motorcycle by providing a brand new motorcycle to the petition number 2. Next page. MSTG Leonard additional PP. Fairly submitted in view of the considering the nature of in view of the nature of offense alleged and the agreement entered between the petitioners being the cousin brothers, she has no serious objection if the present petition is allowed, right?
Yes, sir.
Mr. On consideration of the submissions. Next para. And consideration of the submission of the learned counsel to the parties and the perusal of the materials available in the record of the learned trial court, including the charge sheet. It appears that the police has not clearly established, clearly police has not been able to establish a case against the preface case against the petition number 1, as it is reflected that the charge sheet has been filed against the petition number 1 on presumption of burning the motorcycle of the petition number 2 without there being any evidence collected during the investigation. Therefore, during the pendency, the petitioners had entered into an agreement being the cousin brothers and the damaged motorcycle has been replaced by the petition number 1 being a cousin brothers, and they had entered the agreement, a settlement, without there being any force, coercion, without there being any coercion, huh? Mr. Having considered above the view that no useful purpose, or before that you said, last line, the offense alleged is also not serious or heinous in nature. Last line, huh? Then next para. In view of the above consideration and the materials based on record, I'm of the view that no useful purpose shall be served on continuation of the criminal proceedings of GR case number 255/2019 before the learned judicial magistrate first class Coloring. Mr. I'm also of the view that materials placed on record doesn't primarily establish any offense under section 1. Primarily appears to have not been made on any offense under section 435 IPC. Mr. Does I deem it no, there's in my considered view, this is an appropriate case where the enhanced power of this court is fit to be involved. Then you had that in the same one. Next, then in the light of foregoing discussions and the law enunciated by the Honorable Supreme Court of India, Supreme Court, the criminal petitions and the criminal proceedings of GR case number so and so is hereby satisfied and passed.
All right. Most of it.
Lordship,
Yes.
the government has not been filed their affidavit.
Yes.
Lordship, I'm appearing on behalf of T. Tagum, Standing Council for Education Department. Lordship, we haven't received the parawise comment as well. We need some more time
Okay.
for receiving the.
Heard Mr. So-and-so, learned counsel for the Lona,
Ado, K. Ado.
Ango,
Ado, K. Ado.
sorry. Mr. K. Learned counsel for the petitioners. On MS, are you filing any affidavit? No.
Already filed,
On behalf of
for number 4.
MS P. Sangeeta, Learned State Council has Learned State Council submits that she has already filed the affidavit in opposition on behalf of respondent number 4. Next para, Mr.
Etabang.
Learned Counsel for the Learned Counsel appearing for Mr. T. Tagum, Learned Standing Counsel for the Education Department.
Yes, sir.
Press board and is granted 4 weeks time to file affidavit in opposition. Placed after 4 weeks.
Develop.
Both the cases, huh?
Oh, bless Lordship.
Item number 16.
Lordship, I am for item number 16, Lordship. Lordship,
Yes.
For withdrawal.
Yes, Your Lordship.
We
For
are
withdrawal,
withdrawing.
Lordship.
Why?
Yes, Lordship. Lordship, as per petitioner instruction, Lordship, charge sheet has been filed as petitioner would like to approach the trial court, Lordship.
Yes, Mr.
D. Medhi, Lordship.
K. Medhi.
D. Medhi, Lordship.
D for Delhi. D. Medhi, Learned Counsel for
D
the
for Delhi, Lordship.
submits that he has an instruction to withdraw this bill application. Mr. He pressed for withdrawal of the said with a liberty to approach the
With a liberty, Lordship.
with a liberty to approach the appropriate approach the trial court.
Trial court, Lordship.
MS TG London Register PP is present. Next paragraph. Accordingly, the writ petition, the bail application stands closed on withdrawal with a liberty prayed for. Liberty is also not required.
No, not required.
With
Anyway,
liberty, Lordship.
yes. It's not required, but then anyway. As prayed for, huh? With a liberty as prayed for.
Deeply obliged, Lordship, deeply obliged.
Yes. what
My
is
best,
to
my
be
lord.
done?
My lord, I'm appearing on behalf of my senior Opada. My lord,
This can be listed after vacation, my lord. Paper we have received, my lord.
Okay. Paper book is ready. Have you received the paper book?
Yes, my lord, yes, sir.
Or Mr. Elper Land Council for the appellant. Petitioners.
Petition.
Petitioners. What is this? Washing.
Quashing, my lord.
Washing.
There is a order from court to prepare a paper. book.
Why
This-
paper book is required?
I also believe, my lord, that does not require, my lord. But there's a judicial order, my
Have you
lord.
paid the cost?
Yes, my, I have paid the cost.
You have paid the cost.
Cost, my
Otherwise, they will impose
lord. No, I have paid
for
the cost.
payment. You have paid this.
Paid, my lord.
Then it's okay. No issue. Paper book is prepared. No. Parties have submitted that they have received the paper book, which has been directed to be prepared by this court. List the matter after
Vacation, after vacation.
on the prayer of learned counsel for the parties. List this matter after puja vacation.
Obliged, obliged.
Sir, what is this? What is to be done?
Revision of the pay scale, my lord.
Affidavit in opposition not yet filed.
Not
What's
Your
Last
Lordship,
1 year, madam, they have not taken
yes?
any
Why?
action.
Why?
Your Lordship, I'm appearing on behalf of T. Tagum, Standing Council Education
Where he is?
Department. Lordship, we have received the parawise comment.
You have
this week
received?
only. Yes, Your Lordship, we'll
1 week.
file it shortly.
You
Yes.
file within 1 week.
But as is chance, last chance, madam. As a
No,
last chance.
they have received it. Health department.
Yes, Lordship.
You have nothing to do.
No, I have to.
You have
file-
filed.
Yeah, no, not yet, your lordship.
You
I
are
need
for?
time. I'm for 1, 2, 3, 4, 6, and 7.
Who is the? Okay. So you are not filing.
We'll file.
Okay. And Mr. Tishan, Learned Counsel for the petitioners. MS Arbasar, London State Council has prayed for and is granted 2 weeks times to file affidavit in opposition.
My lord, as a last chance, because last 1 year, they have not taken any step.
But lordship, in the month of
One-
June only, we have received extra copies, your lordship.
Don't start.
They have, yes, your lordship, but still, your lordship.
I have told you, I have indicated you don't talk about this, don't make any submission about the extra copies before this court.
Yes,
Particularly
but-
before this court. Extra copies, you have to understand. Anyway, MS Arbasar, sorry, you just repeated, MS Arbasar, London State Council, and Mr. T. Tagum, London Standing Council for Health
Department.
Health Department or what? Health
Health.
and Family Welfare.
Family.
Health and Family Welfare Department have prayed for and are granted 3 weeks time to file affidavit in opposition. We'll see on next day. Even if you give them 1 week, it's of no use. 3 weeks.
Obliged.
Deeply obliged.
We'll have to. Your matter will be after.
It will take only a minute.
After 2 only. At 2 only.
Election petition, but it will take only a minute.
You have good lunch and come back. Yes,
5 minutes, my lord.
just wait. Item 19.
19.
You are appearing for?
Appearing for the state respondent also.
Who is the state respondent?
Deputy Commissioner.
Respondent number?
Lordship, I'm sorry. 1, 2, 1 and 2, Lordship.
1 and 2.
Yes, Lordship.
What is the matter?
This is regarding Lordship.
Instructing respondent to settle the land dispute local level in contribution to another. What is this writ petition?
We have filed our affidavit and Lordship. Also, records were called for. We have received our records.
You have received the record.
Yes, Lordship.
Last occasion, none has represented. Last 2 occasions, anyway. None appears for the petitioner on call. MSG at the additional senior government advocate is present. Office note dated 21/06/24 reflects that Edikan in respect of respondent number 3, 4, and 5 have been received back after service of notice upon them. What about 6? What about 6? There's no office note on 6. Okay.
6 is also private.
Yeah. Mr. Arsekia and his associates have filed the Bakhalnama on behalf of respondent number 6. However, non-present for respondents. Respondent number 6 today. In view of the above, no, not in view. Now, in view of the above, the services upon the private respondents number 3, 4, 5, and 6 are complete. List for admission hearing after 6 weeks.
Lordship.
Election petition will take only a minute because there is a prayer from both the sides.
Yes.
For extra time.
Hmm.
I'll just explain that, and that's all. So kindly.
You want to rush back to Guwahati today?
Yes.
Have lunch and go.
Better. Sooner we leave, the better. Because no further purpose will be served.
Okay.
Both are seeking time.
Okay.
I'll just explain in a jiffy the
Yes.
reason. So far as the respondent is concerned, we have 5.
Item 29 is it?
Huh?
Item 29. Before that.
Come on,
Okay,
you
just-
are always here. You are always here. She's always here, my lord.
No, 29?
No, 29, after 22, Lordship. Serially, if it.
No, it's
Okay.
item 20.
Oh, yours is 28.
Oh, come on. My lord, so.
Why serially? Where on serially?
Yes.
Where serially going?
She forgot that. She
Yes.
forgot. My lord, in fact,
She also, I think.
she is also in a hurry, so she should not be
She
in
is
a hurry.
also in a hurry.
She should not be in a hurry.
Yes.
Now, my lord, for respondents have filed 3 applications. One, under Order 7, Rule 11,
Yes.
challenging the maintainability of the election petition
That
on
is
various grounds.
That is 183.
That is 183.
Yes.
So please correct me, huh? The second application, respondent have filed under Order 6, Rule 16, that is for striking of pleadings
Yes.
in the election petition.
Yes.
That is number 180.
182.
182.
Yes, 181 is for
No, no.
seeking time to file.
Yes, because my lord, under
WS.
order 8 rule 1, ordinarily 30 days from the date we received the summon.
Yes.
In this case, my lord, we got dusty service. They say on 31st August, we say on 1st September. Be it 31st or 1st September, my lord, on 30th of September, 30 days will be over. You won't be able to. In any case, my lord, unless order 7 rule 11 application is disposed of and the application seeking is striking of pleadings is disposed of, my lord, no purpose will be served in filing WS. In any case, my lord, the further reason we have given is we require 2-3 documents for filing effective written statement that we will be getting within a few days' time. So, my lord, I pray at least for 20 days, my lord, 20 days extra time may be given to us. We'll be filing, and in the meantime, they also seek time. They want to give a reply to our order 7 rule 11 application as well as order 6 rule 16 application.
So we'll allow 20 days time to file.
I would request, my lord, because since it's an election petition and that 6 months period is there.
No,
subject-
that is.
So I'm saying only 2 weeks,
Yes.
maybe instead of.
My lord, if they're in such a big hurry, I'm willing to argue order 7 rule 11 application.
So, it cannot be because on your choice, because it has been served on me yesterday, 3 copies. So I'm only requesting, my lord, because since there's a time bound matter. it's
No, one
subject-
by one.
Yes.
First, if you have no objection.
That
an
can be allowed. I have
objection
no
will-
objection.
We'll have to give the time.
Yes, yes, I'm not objecting. to
So
that.
in IA 81, we'll dispose of the IA 81,
Yes,
181,
yes.
granting him 20 days time. See,
Yes, my lord, 30, because, my lord, they've already filed the reclamation petition.
it's okay.
It's 20.
will.
Sub-
Then,
What it has got to do-
item, sorry, this IA 82 and 83
Ha.
will grant you what time, how much time you want to
That
file?
I would need 2 weeks time, my lord. Lordship may fix a date before 30 because.
2 weeks time, it's
Ha.
not possible because there will
Uh,
be vacation will be.
Just after vacation.
You want
day-
me to have the vacation bench
Absolutely, my
for
lord.
the election,
Uh,
election petition?
No, not at all. my lord.
No, if you wish,
Not at all.
I may make a request to Chief Justice.
Not at all, my lord.
Honorable Chief
Just after the vacation, my lord. Any day after. the
Then in
vacation.
that case, today is what, 27? That's why I'm practical, that's why I'm saying.
Yes.
It's of no use, no point objecting of asking for 20 days. He's
Very well,
taking 20 days. You are saying that 14 days. I
very
said
well. No, I'm saying,
practically,
my lord, my filing, I will make the filing. I will make the filing within 2 weeks time, and then after that.
no, I'll give you 2 weeks time
Yes.
for filing objection, whatever, in
Yes.
IA 82 and 83.
Yes, very
Right.
good. Right. And then Lordship may fix any date after the
And my
vacation.
lord, by 30th October, 30,
Hmm.
on or before 30th October, we will file our WS also. It
No,
may-
no, we're granting you 20 days time. Within this time, you
Yes,
file.
we will,
Okay.
we will.
Then we'll grant them 14 days time
Very
to
well.
file an objection, and we'll accordingly
Very
fix the date on the
3rd of November, this
just
is couple?
reopening of
Third
the.
of-
November?
In
4th
a-
November,
in-
4th November, my lord.
An item
Okay, 4th November.
one, sorry, IA 1, huh? IA 181, huh? Heard Mr. What is the
That's
IA?
how I- Okay. ठीक है, तो
181, IA. Heard Mr. PKT Learned Senior Counsel assisted by Mr. Lamgu. T.
T4, Tamil Nadu.
T. Lamgu. Learned Counsel for the applicant. Public respondent number 1. This is an application under order 8 rule 1 of the CPC seeking seeking grant of extra time to file WS an election petition number 07 of 2024. Now, before that, you just also heard Mr.
Rituraj Biswas.
Rituraj
With-
Biswas, learned counsel for the
with Mr.
opposite party
Kapil.
oblique election petitioner. Then you write that, huh? Mr. P.K. Tiwari, learned senior counsel, submits that the applicant has received the when did you receive the
We
copy?
received the copy of the election petition.
Received the
by the same vote.
election petition by Justimon only on
first.
01/09/2024. Mr. P. He also he submits that the applicant has also filed the applications under section under order 7 rule 11 of rule 11 assailing the maintainability of the election petition, and also an application under order 6 rule 16 for striking of pleadings in the election petition. He further submits that the applicant has also filed a recrimination petition being RP number 01 AP 2024. Therefore, since the applicant has received the election petition by Justimon only on 01/09/24, and the other applications with regard to the maintainability and the striking of pleadings are pending, the applicant may be granted further 20 days time to file his written statement. Mr. Rituras, although submitted that has submitted that has submitted that though the petitioner the election petition was served to the applicant on 30th
August.
08/2024. He would not have any serious objection for granting 20 days time to file WS to the applicant. Next paragraph. Considering the submissions of the learned counsel by the parties. Now, having considered the submissions of the learned counsel by the parties, and also considering that the election petition has been served by Justimon to the applicant only on 01/09/2024, I deem it appropriate to grant 20 days time to file written statement to the applicant. Accordingly, 20 days time is granted to the applicant or respondent number 1 to file his written statement. Next, the election, the IA so stand allowed and disposed of. Well, clear up whatever is there. Will and 182 and 183, huh?
That too has to be, We will file our-
IA 182 and 183. We'll just have a common order.
Yes.
We'll list it on the. Then heard Mr. P.K. Tiwari's answer, huh? Same. Then senior counsel assist the answer. And Mr. Sen. No. Then you said Mr. Rituras. Rituras what?
Biswas.
Rituras Biswas. Learned counsel to the opposite party election petitioner. has sought for, has prayed for and is granted 2 weeks time to
Same
file.
time, I mean, 20 days, same time I'll be given.
20 days,
Same time.
20 days
Because Lordship is fixing a date after that hearing.
to file
Reply to this.
reply or what do we call it? Is it reply or
Reply.
objection or reply? Written objection, oblique reply.
Can't be an objection to when I challenge the maintainability, is the reply only
Huh.
by way of an affidavit.
That's okay. Whatever name we call me ultimately.
It can be objection also.
Yes, yes, it can be.
You are raising in the maintainability. You
Either
can
way,
object.
whatever
Yes, that's what I'm
the
saying.
reply or whatever. We are raising an objection to, so far as maintainability is
And
concerned.
they can have.
They are defending themselves.
Yes, but then they
So
can
that's
also
it.
equally have the objection to your points of objection.
Ordinarily, we call it, anyway, it doesn't matter. These are all nomenclatures.
Yeah.
We,
While objection oblique reply to the IA 182 and 184, 83. Got the 20 days time, huh? Then what is this unlisted?
This
That's where we are seeking time also for.
Then in that case,
from
we'll-
their side.
from their side, because yesterday only.
so in that case,
It
we'll
is
pass
disposed-
this order.
Two IEs have been disposed of.
This,
Their IA and our IA.
So this, not in this case, in the 182 and 83 will pass that
Yes,
order here.
Yes.
Okay.
correct,
Yes.
correct, correct.
In this case here, 182 and 182 will be heard so and so, so and so. Huh? This order will be in the unlisted, huh?
Unlisted.
Then in that case, he will be first, Mr. So applicant so and so, huh? In item IA 182 and 183, heard so and so, so and so, so and so, huh? Listed matter after
On
I
fourth,
think it's 4th of November.
4th of November,
4th of November.
for hearing on this application, sir.
It's better if there is a consensus on the date.
Yes, yes.
Otherwise, it's unnecessary.
Unnecessary.
It will be done.
Hmm.
Even if my lord is not holding the court over here,
Hmm.
through VC we will do.
Do it, we'll do it.
It will be done.
Wherever, huh? We'll do it.
It will be done.
Grateful.
The election petition on 4th.
On
Yes.
4th, 4th of November.
समझ गया? Have you understood? 4th of November, so that everybody understood. What orders should be passed in what IA? And in that thing, this will be heard so and so, huh? In the unlisted one.
Great.
Yes, madam.
Your Lordship, this is a criminal revisions. Your Lordship, in this matter, we have already paid the amount which was filed in the JMFC court, which was the 65 lakhs, which was the final settlement amount. And on the pronouncement of judgment, on that the fine was imposed of 5 lakhs interest.
5?
5 lakh interest was imposed by the JMFC, Learned JMFC court.
Where it is?
It is in annexure number 1, page number 20, Your Lordship.
20.
Yes, Your Lordship.
Yes. What is the relevant?
It is in page number 26, Your Lordship.
26.
Yes, Your Lordship.
Hmm.
Para number 3, Your Lordship. Further, the accused person shall also pay the 5 lakh rupees as an interest to the complainant.
Whether the accused person shall also pay 5 lakhs rupees as interest to the complainant. Yes, then
Therefore, Your Lordship, here we are only appeal for the interest amount of the 5 lakh, Your Lordship. Since Your Lordship, in the Learned JMFC court also, we have from the very beginning, our intention were very clear.
never denied our liabilities. We accept the
So
our liabilities.
therefore, if you have not denied, it's reasonable, 5 lakhs is reasonable.
No, your lordship, regarding the 65 lakhs, now your lordship, we are facing the financial crisis also, your lordship.
Doesn't matter.
Your lordship,
You
our.
have admitted everything,
Yes, therefore, your lordship, we have paid.
checks, pounds.
Yes, lordship. Let's take also, your
No,
lordship, we have paid, we paid for the security purpose.
Sufficient fund.
Lordship, that amount also we have paid for the security purpose, your lordship. Since the parties,
Are you saying under the law, no interest can be?
In fact, twice the amount can be recovered, Lordship. In fact, twice the amount can be recovered as per Negotiable Instrument Act. However, only 5 lakhs interest has been imposed. And
What you were saying?
in fact, twice the amount can be recovered
Yes.
in default of in check bounce cases. However, only 5 lakhs interest has been imposed, and the matter was pending for a very long time, and the complainant has suffered a lot because he is a contractor by profession and he has invested a lot of money, and the loans have been increasing over time.
You are agreed by this person only. Everything is admitted,
yes, your lordship.
right?
Yes, your lordship.
It's reasonable enough.
We have agreed to pay the 65 amount, which was the final
Yes,
settlement
that is,
agreement,
that is
and
what.
that was
That
paid,
is,
your
that
lordship.
is the respondent is, it's his rightful amount.
Now, your lordship, we are also facing so many financial crises, your
No,
lordship.
that's
We have
not-
annexed the.
See, this is a revision petition.
Yes, your lordship.
You are not filing there cannot be a mercy petition. Either you have to show that this is 5 lakhs interest is not in accordance with law. Then will interfere.
And your lordship, this 65 lakh rupees was, regarding the 65 lakhs rupees, before pronouncing the judgment, we have already paid the more than 60% of the payment.
It's all
And
right. It's all right. It's not because of the default or something like that. Its interest has been given reasonably. All right.
If I may say something, like from the very initial stage.
Or it's okay. I'll suggest you how much you can pay. 4 lakhs will reduce it.
4
Interest
lakh
rate
is a huge amount, your lordship.
No.
Recently also, your lordship, the-
Otherwise, I have seen your petition.
Sure.
There's no reason, there's no ground to interfere.
Lordship, since our client is like already facing a financial
It's all
problem,
right. It's respondent's amount.
imposing a
Your
5 lakh
price,
is a very
your
hefty amount.
payment, your financial crisis and all those things will not, that cannot be ground. We can modify it up to 4 lakhs.
No, Lordship, the complainant has suffered a lot. Any kind of modification lesser, if the amount is lesser than 5 lakhs.
Heard MS so and so, learned counsel for the petitioner. This is the impugn order.
Yes, your lordship, this is the Indian. Yes, your lordship, this is the Indian order.
The petitioner is aggrieved by the judgment and order dated. This is judgment and order.
Yes, sir. This is the judgment, your lordship. Yes,
Petitioners, how many petitioners?
3 petitioner, your lordship. And regarding the petitioner, number 3 is your lordship, she is suffering with health issue, and also your lordship, recently she has been operated with her left and right TRK, your lordship.
Judgment and order dated 15/7/2024. Passed by the
London JMFC Court, your lordship.
Judicial Magistrate First Class UPI. And dated and order dated 03/09/2024. Passed by the. Now you read that. Agreed by the 15/7/2024. Has filed an appeal to pass by the London Judicial Magistrate First Class UPI.
Yes, your lordship.
Filed an appeal against the appeal before the appellate, lower appellate court. No, appellate court below.
Thereafter, Lordship, they appealed before the session court as well.
That's what I'm saying. No, no, then
That
in that
was-
case, you're right. By filing this petition, the petitioners have put to challenge the orders dated 15/7/2024 and 03/09/2024 passed by the Judicial Magistrate First Class plus, UPA and the appellate court below. District Judge
Yes, sir.
within bracket, Public District Court, UPA. Whereby the petitioners have been held to be guilty of offense under Section 138 NI Act. Thereby directed the petitioners to pay 65 lakhs to the complainant oblique respondent and also to pay rupees 5 lakhs as interest to the complainant respondent within 15 days with the default stipulation that the petitioner, the petitioners shall undergo 6 months of imprisonment. Where's the appellate's court order?
It is in page number 30, Your Lordship.
30.
Yes, Your Lordship. Annexure number 2.
The appellate court below, the appellate court below has dismissed the appeal of the petitioners. And directed to hand over the demand draft to the Land Council for the no. Dismiss the appeal of the petitioners. List of issue notice. You are not filing any appeal against this. Have you filed appeal?
Against, yes, no, they are the,
Because you said that as per the law,
yes,
you are entitled to be the interest double the amount.
yes.
But the court has only imposed 5 lakhs.
No, I'm
As
happy with
interest.
5 lakhs, Lordship. I'm okay with 5 lakhs. The learned judicial magistrate first class has imposed 5 lakhs as an interest.
Then
Thereafter, they have appealed to the
that's why I'm suggesting this court is suggesting you to accept 4 lakhs.
Lordship, because of the actions
If
of
you are
the
not agree, you will issue notice.
Lordship, because of the actions of
Mr. So and so issue notice retirement by 4 weeks. Mr.
HRP.
Learned counsel for the petitioner entered appearance and accepted on behalf of the respondent.
Lordship, if 1 minute of time may be given.
Huh?
Lordship, in fact, the total amount is 1 crore 50 lakhs.
Are you
Lordship,
filing an appeal against this? Have you filed an appeal against the order of the magistrate?
No, they have filed the appeal, Lordship.
That's what I'm saying. You don't argue all those things which is not, which you have not, which you are not agreed. See, you are entitled maybe 10 crores, 20 crores, but then trial court has found that you are entitled for 65 lakhs
Yes,
and imposed an interest of 5 lakhs.
yes,
So you are happy with that.
yes.
So in that case, don't argue whether you are entitled to 1 crore or 10 lakhs, something like 10 crore. Don't say that.
Yes, Lordship. I'm only on, Lordship, I'm only on 5 lakhs, Lordship. I've already received the 65 lakhs
That's
of the
why
amount.
we are issuing notice. Whatever you want to say, you say.
Oh,
In IA, we are staying the execution.
Lordship,
In IA.
Lordship, in that case, they will have to challenge, also challenge the recovery petition which I have filed before the learned judicial magistrate
You
first
do
class.
whatever you want to
After,
do. All right.
Lordship, 15 days of time was over as given by the learned judicial magistrate first class. We've already filed the
Issue
recovery.
notice
Yes,
in
only.
IA. Huh? IA heard so and so, so and so. Issue notice. Huh? The
No, a
mis-
stay may be given, Lordship. Only notice may be, it may be admitted, but no stay may be given, Lordship. No stay may be given on the IA, Lordship.
What you are going to do it? What's the use of keeping it pending if there is no stay?
In that case, they can also file an appeal against the recovery petition, Lordship, separately.
Anyway, issue notice on IA. Next date we'll see. Nine.
Your Lordship, I'm appearing for resolution number 2 and 3, Your Lordship.
2 and 3.
Yes, Your Lordship, we are yet to receive our instructions.
My Lordship.
Lordship, as per order dated 24/2024, Lordship, I have to submit the proof of forwarding of order dated 2/8/2024 to the DLRS, Lordship. So
What is this?
the forwarding of order, Lordship.
Forwarding of what?
Lordship, order dated 2/8/2024, Lordship, to the respondent number 3, DLRS, Lordship. As per order that I have to submit this service report to the Honorable Court, Lordship.
Mr.
K. Lolan, Lordship.
Counsel for the petitioner has produced a copy of the letter which indicates, which reflects that the certified copy of the order dated 02/08/2024 has been You're supposed to give it to the DLRSO.
Lordship, I served to DLRS and the Deputy Commissioner,
Okay.
Lordship. Board of Officers, Lordship.
Okay, what is that? Indicates, Served to the Deputy Commissioner, Capital Complex, Itanagar, as well as District Land Revenue and Settlement Officer, Capital Complex, Itanagar, within bracket, respondent number 2. which is taken on record. Next paragraph. Office note dated 23/09/2024 indicates that the postal receipt dated 03/09/24 has been received from the postal department from the Naharlagun post office. Who is respondent number 4?
Private respondent.
I'm appearing on behalf of respondent number
Okay,
by filing Mukalar number.
okay. Which is also taken on record. The Mr. Udeka. Police Department. Before that, however, the report service board in respect of respondent number 4 is said to be awaited. Please stop. Mr. In respect of respondent number 4, said to be awaited. Mr. Udeka. London Council. However, entered appearance on behalf of respondent number 4. Therefore, service is complete. Next paragraph. What is to be done? What is to be done? You need some time.
Filing.
You also?
Yes.
Yes, you also.
Yes, Your Worship. I'll take.
Both P. Sangeeta, London State Council, and Mr. Udeka, London Council for the respondents have prayed for a granted 3 weeks time to file affidavit.
Of license.
3 weeks time to file response. The copy of the letter dated 05/08/2004 submitted, placed on record by the London Council where petitioner is kept on record and marked as annex, the documents number, documents A.
Of license.
32, 34, they have mentioned. Has been adjourned. Are you on bail
Yes.
next week
In that case, after vacation,
after vacation?
otherwise, this is a case, there's absolutely no evidence.
Do you have any defense? Do you have any ground to defend? The
Yes, Your Worship, there is-
judgment and conviction and sentence
164 statement is there.
only.
And that is statement, one FIR, though 161 is not admissible, but FIR 161 or 164 full are consistent.
Hmm.
And injury report, doctor opined that there was injury over lips, over chest.
Conviction is of
3 years.
sentence.
3 years.
3 years.
3 years for 354 B, capital B. 354, 1 year. 1 year. 354 B, 3 years. 3 to 3 simple injury, only 5. 1,000.
So according to it's 4 years.
No, only 5 years. No. I'm appraising the record of it.
Obviously, how you will.
Prosecutors never came before the honorable. Vital witnesses were not examined. The fatal.
After the
On the joint prayer of legal consent with the parties. List this matter after Puja vacation,
Well.
after Durga Puja vacation.
All right. All right.
If had you not been on bail, I could have.
Yes, otherwise
Look,
it's nothing much because
It's all right.
honorable court is clear. That evidence, I was not allowed to cross-examine. How can that be taken into account?
Oh, yeah.